Okay, council, we're going to receive announcements in Texas Central Business Lines Corporation versus U.S. Polyco for the second oral argument on March 2, 2022. If you could identify yourselves, let me know if you are going to be doing the arguments or if you're going to be splitting time, and then if there are any preliminary matters that we need to take up. So the case is TCBL versus U.S. Polyco.
David Johnson and Mike Wright on behalf of Texas Business Lines appellant. I will be doing the oral argument for appellant.
And y'all are not going to split time.
We are not.
Okay.
Michael Peck for U.S. Polyco Inc. And I'll be handling the argument.
Okay. Any preliminary matters?
We have Polyco filed some documents last night, but we filed a motion to strike it because they're not in the court's record. And so he has demonstratives that are here today that we do not object to. They were used in the trial court. But as to, I don't know if he plans to talk about that as his argument, but if he does, we would object to that argument, but object to the courts looking at these filed documents that were in the court's record.
Okay. Response?
Response, Your Honor, is the two filed documents. I've turned them a handout. They are taken from Westlaw. It is a Fifth Circuit opinion involving TCB, where they took a particular position regarding infrastructure related to transloading. The second document is also on Westlaw. It is the brief that TCB filed in the same case, stating the positions they're taking, and then you can see the ultimate resolution in the Fifth Circuit opinion. Twofold, Your Honor. They take a different position about infrastructure in that case than they're taking in this case. That's not really what's important to me. There's an issue that they're going to argue about whether a reasonable jury could find that the infrastructure was for the purposes of TCB's train operations. In that case, they argued that the structures, the foundations, the road, etc., were all part of TCB's train operations, so they could avoid regulation by the city of Midlothian. What I was going to point out, and again, we just saw Mr. Fields talk about a case that he had argued and what the facts were of that case and how it applied or didn't apply. We have a reported case that involves similar issues. I believe it's important that I can talk about the case because a reasonable jury could accept the argument we're making in this case because they made the argument. Certainly a reasonable jury could accept it if the Fifth Circuit could accept it. I just want to be able to talk about that and point that out. Again, it's a reported case.
Are you arguing it for its precedential value or its factual application to this case?
I think neither, Judge. I think what I'm arguing it for is if they get up and say, well, there's no way the jury could have accepted this as being part of TCB's transportation operations because a reasonable party couldn't accept that. I would simply like to say we have a reported opinion where the Fifth Circuit accepts an argument similar to that. We think that applies as well. So I'm not arguing that it's binding on this court in any manner. It would be basically, I don't know how you would phrase it, descriptive, I guess, Your Honor, of a reasonable scenario that could be accepted by a jury.
Response.
Thank you, Your Honor. So first of all, there were summary judgment motions in this case. They could have attached this stuff to their summary judgment motion. They did not. They didn't offer it at trial. It was a completely different case, completely different issues. It wasn't a case between TCB and a customer over their road allowance agreement or their transloading agreement. It was between TCB and a municipality over regulation. And so the issues are completely different and the contracts are completely different. The only evidence in this case shows that this provision 1.1.
Let's stick to the motion for right now.
That this provision is not in the contracts that are the basis of that case. So it's irrelevant and it was not in the record, and for that reason it hasn't been cited in their briefs. And so for that reason we'd ask the court not consider it.
Any questions?
No, you covered it.
What we're going to do, we're going to leave it as an oral argument exhibit. So to that extent, we're going to overrule your objection. But we know our limitations on what we can consider in this appeal and what the scope of our review is, limited to that record. And if there is case law precedent that is appropriate, we can consider that, but it is not, I think you said it's a Fifth Circuit opinion, obviously not binding on us. And so we will proceed with them. You can use them if you want to. You can talk about them any way you want to. And, but we will be confining ourselves to the record that is before us when we make this decision. So with that understanding, you may proceed when ready.
Now, one other issue.
Oh,
We're
excuse me.
in complete agreement with that. We also discussed, there's an attachment to the contract. This, which I talked with counsel earlier, they don't appear to have an objection to me using it.
Yeah, I think my understanding was your demonstrative exhibits unrelated to what you had filed last night were fine with
Correct.
the appellate.
All right.
Okay. Counsel, you may proceed when ready.
May it please the court, Mr. Peck. I appreciate the court's time today to discuss this case, a very important case to my client. This case involves a complex business dispute with lots of different moving parts to it. This certainly isn't a contract to sell 10,000 widgets for $1 million. This involves the construction of complex facilities for the transloading of materials from trains to trucks, and then in between that, altering the products. But when you boil the case down, it really involves very simple contract construction issues with regard to the issues in this case. Fortunately, the trial court ruled incorrectly on these basic contract construction issues in a pre-trial motion for partial summary judgment. That ruling then made it into the case with regard to how the evidence came in. It made it into the jury charge saying, jury, you have to review the contract this way. And then, of course, it leads to an improper jury verdict. TCB was hamstrung at trial with regard to how it could present its evidence, what arguments it could make. And we asked the court to correctly review the contracts de novo, as is the court standard of review or contract review, and reverse and render for Texas, for TCB. The alternative, we asked the court reverse and remand for new trial if the court feels that the contract is ambiguous. One of the basic principles of contract construction is the court must look at the facts and circumstances of the party's business and their dealings in construing the contracts and the language that they use. So
Do we do that though on the front end or only after we determine that there is an ambiguity in the contract?
The cases say you can do that at the front end. They say you can, it's not really so much looking at the party's intent for what this term means. And I think it means this, and you think it means that. It means what are the business dealings between the parties? And if we're going to use this term in this contract, we have to understand what this deal is supposed to accomplish. And the courts say you can do that at the front end, whether there's an ambiguity or not. Here, TCB is a small company. It's a small railroad. I say railroad, it operates in one distinct yard, a very distinct yard because it has BNSF and Union Pacific tracks meeting. So it's a really important position because customers can use either railroad to be able to transload their product. Polyco is a much larger company that does polymer-based asphalt. They get this asphalt, they add polymer to it, they do their magic, and they come up with a product that they then distribute to their customers across the United States. Polyco wanted to use TCB services at this railroad center to be able to transload their asphalt from trains into facilities that they would own. They would then add polymer, change their product, and then put it into their trucks and drive them off to their customer. When TCB enters these sorts of contracts, it's a very small company. It doesn't have a lot of capitalization. It can't go out there and make millions and millions of dollars with construction to these areas to be able to allow customers to be able to do what they need to do. And oftentimes it requires a lot of construction. Here, it's undisputed that the designated area for their transloading operations was just raw land. There was no utilities out there. There were no roads out there. They had to take a four-wheeler out there just to look at it and say, yeah, this is where we want to build it. So when
Is the record going to show whether or not there were other designated areas for other customers at this general intersection that had this type of construction project involved? Or is that outside this record?
Well, I believe in the record attached to the agreements, you will see a preliminary survey, if you will, of where the facilities are. It doesn't show a quote designated area for other customers, but you can see other customers could use the other side of the tracks. So I'm not sure if that answers your question, but there is a plat, if you will, of a preliminary plat of what it was going to look like. And you can see open areas where other customers could come in and use the track, for example. Okay.
So how encompassing is Exhibit X in what we're going to look at?
Exhibit X is a preliminary plan or plat. And it's important to understand at the time the railroad allowance agreement and the transload agreement were signed in 2014, they knew where the designated area was. They knew where we were going to build this thing. And so we knew we need to have tracks going out there. And we knew we needed to have a road going from there back out to the highway. But that's about all we knew. They didn't even have their engineer design their plans for their facility until a year later in 2015. So at the time that we are negotiating these agreements, we don't know exactly what their facility is going to look like. And there are things on Exhibit A that are very clearly their special handling equipment, their sole purpose facilities, and there are things on Exhibit X that involve our railway and roadway that we completely agree is a TCB's infrastructure. So it's not all, it's preliminary, it's all encompassing in the sense it has both of our stuff on it, but it is not limiting in the sense that that is what TCB's infrastructure is.
So the subject matter covered by Exhibit X is encompassing. But of course, we have to look at other documentation or perhaps oral agreements that's also up in the air here.
Correct.
That we have to do that in addition to Exhibit X as we go forward.
Exactly, Your Honor. And if you look at paragraph 1.1 in the RAA, Road Allowance Agreement, this is, Exhibit X was attached to the transload agreement because it showed where the designated area is. The transload agreement allowed them to come on our property and do their transloading. The railroad allowance agreement is kind of like a financing agreement. It says you're going to, customer, you're going to pay for up to $1.2 million of our infrastructure. And then we will pay you back over time by giving you discounts on future services. And also it encourages you to use our facility so you can get these discounts. So in 1.1 of the infrastructure, of the RAA, it defines infrastructure improvements. And it says as used in this agreement, TFB's infrastructure improvements will mean the following improvements agreed to and shown generally on Exhibit X. So it says generally. It says generally because it's preliminary. It could change and they don't even know what their facility looks like yet. And so it doesn't just stop there. It doesn't just say, infrastructure improvements is Exhibit X, period. It goes on and says, one, it includes 3,000 feet of rail track. We knew that because we knew how long it would take to get from our existing track to this new designated area. Two, approximately 6,000 feet of two-lane improved roadway because we knew how long it would take to get from this designated area to the highway. But then because we did not know what their facilities would look like, we say various concrete and ground surface improvements as agreed to by TCP in these areas. And it was very important to say as agreed to because we didn't know what it was going to be. What if they put an arcade out there for their employees to use? That would have no benefit to us whatsoever. We weren't going to say, yes, that counted towards our 1.2 million, we're going to pay for it. But that gets a little ahead of my argument, but that's completely fine. I'll try to catch back up now. So we have the transload agreement that actually has multiple different portions to it. It allows you to come in. It also says TCB is going to front the cost of doing utilities. We're going to put the utilities, because there was no utilities out there, we're going to make sure the utilities get out to this designated area. But then it says you're going to reimburse us for it. And you're going to reimburse us for it as soon as we give you the invoice and supporting documentation. Then we have the railroad allowance agreement, which is a different agreement. It's secondary. The transloading agreement is the agreement that says you can come in and do your transloading operations. The railroad agreement allowance agreement is really very specific, dealing just with portions of infrastructure that benefit us, TCB. That benefits TCB's operations. We're going to have control over it. We're going to own it at the end of the day. You can't take it with you. And in fact, if you leave it, you got to destroy it and put it back in the same condition you found it in. And it deals with the customer paying up to 1.2 million, and then us once again paying it back to them. So it's kind of a cash flow way of getting this stuff done. So the rubber hits the road in this case, where you have TCB does the utilities, you send them the invoice, they refuse to pay for the utilities under the transload agreement. Separately, under the RAA, they have $1.8 million they claim as TCB infrastructure improvements. Over $1 million of that was for 3 specific contractors, 5 Point, MISCO, and DRD, and they were doing the slabs under their tanks that holds their material and makes their new product, and under their warehouse, and also built the tanks and also built the warehouse. That's what that money was for. We never agreed to any of that because none of that benefits TCB in any way. So we didn't agree that that met the 1.2 cap. So therefore, we did have another contractor, J Mills, who actually did road grading for the roads, point one, they did grading for the rail track, did grading for these roads, and the parties had a written agreement agreeing to it. We submitted that to Polyco and said, here's the invoice, pay for it. They actually paid for the first $300,000 or $400,000 of it, and then stopped and said, well, we met our $1.2 million cap. And we said, no, you didn't. We didn't agree to that over $1 million worth of stuff for your personal warehouse and your own personal tanks. And thus, this dispute happened.
So does there, on subparagraph 3,
Yes.
does the 1.2 million that you described financially speaking is separate? And they had hired 3 contractors to be doing concrete work and what else?
Well, building, they did slab work under their own tanks and their own warehouse.
Okay, but that was not part of 3?
No, sir, it was not, because we never agreed to it.
In spite of the fact, bear with me a minute, in spite of the fact that you had just presented to us that we all really, the parties did not fully know what was going to be covered by 3 as you signed off to begin with.
Correct.
Okay, help me with that, please.
So contracts can leave things open for future agreement. And this is a perfect example of that. We know we want to have transloading, and we know we're going to have stuff coming off of trains and putting on trucks. But we don't know exactly what your facilities are going to look like. Maybe they wanted to change their mind. Maybe they didn't want to mix it there. Maybe they wanted to just take it off, send it somewhere else, and then mix it there. And so a year later, they come up with their engineering designs for what they want their facility to look like. The point of, so part 3 is, since we don't know what your facility is going to look like, we're going to have to agree in the future that anything you build out there counts as TCB infrastructure improvements. It's not saying they couldn't do it. It's saying that if they did it, they'd have to pay for it. If they wanted to count for TCB infrastructure improvements, then it would count against this 1.2 million, and TCB would be paying for it via these discounts and future services.
Okay.
Does that make sense?
Yes, sir. As far as your position
My argument,
goes,
I understand.
yes, sir.
Thank you.
Well, the quick question I'm going to just vault to is they want to talk a lot about a comma.
Right, I want to get to that.
So let's just jump to that.
And that's exactly, thank you. That's exactly where I'm going. So it gets down to this paragraph with regard to our first contract construction issue. And here we have infrastructure improvements is a defined term, has 3 parts, all set off. So we have a colon, we have semicolons between them. Part 1 is something we all agreed was infrastructure, the track. TCB infrastructure. 2, we all agreed that the roadway was TCB infrastructure. And it says semicolon and 3. And so it says various concrete ground surface improvements, including without limitation. So what follows is a unspecified list that's not limiting. It's not exhaustive. And then at the end of this non-exhaustive list is other items in or adjacent to the designated areas. And then we have as agreed to upon TCB and customer in writing. They say there should be a comma there if you wanted to interpret it the way that TCB wants to interpret it. And that's the way the trial court, in our opinion, misconstrued the canon of last antecedent. Last antecedent construction says that a qualifying phrase should be applied only to a portion of the sentence immediately preceding it. So that begs the question, what is the portion of the sentence immediately preceding it? The trial court said, well, that was other items. But if you look at the correct application of the canon of last preceding, it actually applies to the entire subpart of 3 because it is set off. And we have a case in the briefing that's pretty much exactly, I mean, obviously not the same contract, not the same language, but stands for the principle that we're talking about, which is note investment versus associates. And there we have a sentence that says monetary claims dash, including attorney's fees, comma, interest, comma, and cost, that would be recoverable up to the time of the offer. The modifying frame that would be recoverable up to the time of the offer was in dispute. Was that just for costs or was it also for attorney's fees and interest? Similar to the construction we have here. The court in that case says, no, because that part of the sentence was set off, that modifying term applies to everything in this set off area, which is exactly what we have in this contract. Their argument and the trial court's construction may make more sense if subpart 3 were a standalone sentence. If that was the only sentence we were dealing with, then a comma here would have a stronger argument. But it is not. It is a very, very lengthy sentence, and part 3 is set off by itself, and so the modifying language in there applies to all parts of subpart 3. And that also gets to another canon of construction that's in our briefing, the series qualifier canon of construction. It is, as Justice Scalia and Mr. Garner cites, says when there is a straightforward parallel construction that involves all nouns or verbs in a series, a pre-positive or post-positive modifier normally applies to the entire series. And we have 3 or 4 cases that expressly cite to this series qualifier canon of construction and construe it exactly the way TCB is construing it in this case, which is you don't need a comma here at the end because they're saying if you have a series of things and it's all in the same order, verbs or nouns, then the post-positive, so pre-positive, so there's a modifier in front, or post-positive modifier in back applies to everything in the series. That's exactly what we have in this case, and these cases apply and support our interpretation, as opposed to the trial court's construction, which is which doesn't talk about this statutory construction and misapplies the last antecedent construction. Most importantly, so the canons of construction support our view of it, and this court's de novo review of what the language means. But really, more fundamentally, and once again, the court shouldn't make an unreasonable interpretation of contract language, which is what the trial court did in this case. It's unreasonable because, one, it ignores language that's in it. This modifying language, as are agreed upon by TCB and customer in writing, is completely meaningless under their construction. Once again, this is a non-exhaustive list of items that describes various concrete and ground surface improvements. It doesn't say these are improvements that are 1, 2, 3, 4, 5. It says that include. So there could be other things that fall into this category. Those other things that fall in must necessarily be agreed to upon the parties.
Trying to shorten this argument because they're going to argue that that word agreed in the introductory phrase meant that you agreed basically to everything on the incorporated Exhibit X. How do you respond to it?
Well, that's not true, because if you look at Exhibit X, it contains things that are clearly not our infrastructure. And you can look at it, it's got their facilities that both parties agree was completely their stuff, not our stuff. So their interpretation of that is unreasonable, and the trial court, I don't think the trial court went on that direction. They didn't really talk about that.
You think it was just a comma?
It was just a comma. The
Okay.
trial court was just a comma. And secondly, this gets to the bigger point, which is what I just mentioned, which is that please read the railroad allowance agreement. It's not that long. And it'll take you 20 minutes to look through it. And you will see over and over and over, TCB constructs, TCB has control, TCB is going to do all this stuff. There is a small exception under 2.1 that says in the event, first talks about us building everything and us having control. And then halfway through it says, in the event that the customer, Polyco, directly contracts with someone to build TCB infrastructure, then TCB will have the ability to approve it. So the entire point of this agreement is that TCB will have control over it, because in the second sentence, it says, all of these infrastructure improvements are constructed and provided for in this agreement will be the sole property of TCB upon completion and are intended for the primary use of TCB in the context of its road operations. Everything on Exhibit X is not intended for the primary use of TCB. And if you follow their construction, it's completely unreasonable, because they can put in anything that they say is various concrete and ground surface improvements without our consent and have us pay for it. And that's not what the agreements say. And it's completely contrary to the entire purpose of the railroad allowance agreement.
So do we, two things. One, we'll go along with you about that word competition there, meaning completion. I don't see how it'd be any other way. I'm talking about that word next to last on it right there. It says on competition.
I think
That's
it's
not what
completion.
anybody intended. It was
Sorry.
completion. No, I mean, you read it right, and we'll live with it like that, because that's not part of the argument, but I just noticed that. The other thing is, to me, of course, it's a damages case, so it's all about money up to a point, right? Okay, the 1.8 million that they argue that they spent, the agreement that you had with them about 1.2 million. The business a while ago about the generic nature, I'm sorry, live with my term, if you will, a minute, for number 3, subparagraph 3, the generic nature of it. Y'all fine-tuned what it really meant, who had to pay for it in other places, other documents or whatever. Is that the way we should look at it, including what you're talking about having to do with the comma?
So,
Because they paid 1.8 million,
right.
yet you were going to get up to 1.2 million back over the long haul,
Right. Well,
or down the road, so to speak.
it's really about who pays for it first. And so the first 1.2 million is paid by them.
Yes, they fronted it. I
They fronted
understand
it.
that.
And so they're saying, we met our 1.2 million because we just got 1.8. And our point is, no, you only spent 600,000 because over $1 million of it, we don't agree with. It wasn't for our benefit, and it's not our infrastructure.
Was it their 3 contractors, if you said, as you said, the 600,000? Is that who you're talking about?
Yes.
That they paid for and you get to eat it, that 600,000, because those are your 3 contractors.
No, it's their 3 contractors.
That's what I'm saying. They're
Yeah,
3
exactly,
contractors. That's what
exactly.
you're arguing.
Correct. It doesn't count towards the 1.2 million and so you still have to pay for the 4th contractor.
Right.
We submitted to you, you had to pay for it, and they didn't.
Yeah.
And they should have.
What is the difference between what you contend that they should have paid and what you were not paid?
So it's roughly, so they say they paid 1.8. We say over $1 million of that doesn't count. So we say you paid around 700,000. So we say that there's still $500,000 to $600,000 inside the cap that they refuse to pay. Does that help?
And did y'all exceed in TCB infrastructure improvements as you contend it's defined? Did you exceed $1.2 million in construction costs? Ignoring right now the TA and the The utilities that
Yes.
is mentioned in the TA.
Right.
Ignoring that
Right.
obligation to reimburse you. Did y'all exceed the 1.2 million?
Yes.
By how much? Is it clear? Okay, don't worry about it. Go on.
Or to follow with the chief on that, is the record gonna compute that number, that series of numbers he's searching for?
Yes.
So when we get into your, the reporter's record, that's going to come in.
I believe there were exhibits that showed how much they paid, how much we paid, and I think it's all a part of the record.
Okay,
Okay, good.
And so,
go to the issues on the charge.
okay. The issues on the charge it's pretty simple. They have an instruction in the charge that they asked for and the trial court gave that said under this.
Let me be more specific.
Yeah.
Charge issues on the TA.
Right. Very good. Thank you. So under the TA, the jury was asked, did they breach the TA? And the jury said no. And all the evidence shows that they did. They showed that we did the utility work, and we paid for it, or most of it, a lot of it, and we submitted them an invoice, just like we're supposed to do, and then they didn't pay it. So, I mean, that's pretty black and white.
Is the record going to be clear on the timing of that versus where they argue you were seeking payment for the over 1.2? In other words, their 1.8 that they had paid under their argument for the infrastructure improvements, where does that fall in relation to the TA failure to reimburse you for the utilities?
Separate agreements, and each of them has.
Are they?
They are.
No, they're separate documents.
They're separate documents.
I'm going to play a word game with you here because we've got two documents. All the case law says we construe them together. And
you can strew them together in the terms of, in the way of saying that, what does this mean? And you go into the other document to give import. But under the railroad allowance agreement, it expressly says, and both contracts have this provision that says this is the entire agreement. There's no other agreement that controls the subject matter of this topic. So I think for the part of, as far as our claims are concerned, or anticipatory breach, is what you're saying is, well, maybe you breached first, so they didn't have to do this. Each of these are standalone agreements in the context of our claims they're under. Now, they are integrated. They do mention each other. So you have to look at them for various rights or whatnot, or how you define certain terms. But if we have a claim under the TA, we have a claim under the TA, and if they breach or we breach the RAA, doesn't mean they, so you may have offsetting claims. That their damages may be more than our damages, and you would offset them. But the jury got it wrong on the TA because it was very clear we did utilities, we sent the invoice, and they didn't pay it. Their only argument is, well, the TA never got started because you didn't do it within the term. And the problem with the term argument is that, well, the term is only started after this whole thing was built, and we got trains coming in, and it says, you have to let the trains come in for 10 years. And it doesn't talk about what do you do for expenses. The term doesn't limit the payment of expenses getting up to the term. And so it's very clear under the TA, and especially says, we do the utilities and you pay for them as soon as we send you the invoice. It doesn't talk about the term. It doesn't say we send you the invoice during the term and then you pay for it. The term is completely ignored in that portion of the TA. So their argument is.
So it's your contention that the TA, while the payment term started at some future point in time, the obligations they're under were current.
Exactly.
Okay.
I mean, we acted under it. We built the utilities, so they have to pay for them. And I know I'm running out of time. I think you may have given me extra time, which I appreciate.
He's very good about that. Don't worry, you're gonna get it too. Hey, can I ask you about that?
Yes.
In that area and having to reconcile the fact that, as the chief property says, there's two agreements, that's not necessarily, two documents, not necessarily two agreements. It depends on what you're talking about. There's no reason to believe that we don't also have, and I'm trying to remember, this is an old enough case, it's not burdened by it. the full record. This is one of those, I understand lawyers make closing arguments and I understand they make, shall we say, expansive interpretations. I got that. But the arguments in this case, I would think, addresses each document, the major documents, and how they work together. Why? Because the jury failed to comply, no, on both questions 3 and 7 on TA. They didn't find that either one of you violated those, and that somebody was telling them something that made them believe that didn't have anything to do with it ultimately, as far as the case, because 3 and 7 are very clear, no and no. Now, I understand, we all went to law school. The answer of no is not necessarily a negative, if you will. But it sure concerns somebody that this case was simply limited to the other document plus whatever you guys agreed to, your clients agreed to. But as far as you know, my question is ultimately, is the closing argument up here with the case as far as you know?
Yes, it's part of the record.
I know there wouldn't be any reason not to. What that would be strange in a case like this to waive oral argument.
Correct. We
As
had
far as
closing,
recording.
correct. Oh, I don't know if it was recorded, but we had closing argument.
Well, of course, it's not recorded. It won't help us.
Right.
But we could go look at
Well,
it.
it's
if
transcribed,
recorded.
yeah.
It is transcribed as far as you know.
Yeah, yes.
Yes.
But I will
Okay.
say that, I mean.
Well, you
closing
guys didn't
argument-
try the case. You didn't.
I didn't, Mike did.
Okay,
And-
Mike, it's there. Excuse me.
Yes, Your Honor, it's there.
So if we
Yeah,
want to
it's-
go peel through it, we can look at it.
We have a complete record, a complete reporter's record, yes, Your Honor.
Okay, and I don't mean to be informal, but I'm not here all the time. Okay.
I would say you have to be careful about looking at it, because once again, we didn't want to contradict the trial judge and have the trial judge fuss at us.
Well, I
because it
know,
was
he might
pre-trial
have fussed
ruling.
at you. You think maybe he didn't agree with you about his ruling on the partial summary judgment?
Exactly.
I
And so
got you.
we had to follow his
Oh,
ruling.
I know, you had a tiptoe.
Exactly.
But somebody convinced this jury that 3 and 7 got answered like they answered. To me, that's puzzling about the case. And so since I'm the extra spare here, I might want to go look at that.
Okay.
Okay.
Thank you.
Time up, thank
Yeah,
you.
you'll have 5 minutes, unless there was something really brief that you wanted to say.
I could say one thing really brief. Even if you ignore everything I said under 1.1, we still win on this contract construction issue under 2.1, but it says we have to agree to anything they do with the contractor on their own, which is exactly what we're talking about on those three.
Okay, hey, I'm glad you went there. That was a factual dispute as to whether or not the engineer approved it, because I know that's what you're going to argue. So how do you respond to that? That was a controverted fact at trial as to whether or not Lunsford approved those specific portions of the project.
Very simple. Look at the record sites, what they say. I have a lot of respect for Mr. Peck. What he says is not supported by the record. If you look at our reply brief, we specifically go and look at the record and say it does not support what they say. So there is not a fact issue on that. They say there is, but there is not.
Okay. Questions before we leave the first round?
No, sir, I'm good.
Okay.
Thank you.
I forgot you had a timetable.
Hey, since one of mine is a one-liner, as far as you know, then we have the trial closing argument by the lawyers.
Yes,
It's
Your
up
Honor.
here,
Yes, Your Honor, I believe it is volume 10.
volume 10.
I believe so, volume 9 or 10.
I appreciate that.
Okay, council, let's reset the clock to the original 20 minutes. If we need more time, I'm going to give it, but I forgot that one of the judges has a departure schedule, and so we're going to try to,
Oh my God, I'm sorry.
That's fine.
to get this done. So
And
you
in
may
fact,
proceed, when ready.
I'm sorry, Steve, I didn't know that.
How'd you know it was him, Lee?
No, you're asking enough questions, you're not leaving.
may it please the court,
You're both taking
Counsel.
time. Go ahead, counsel.
Mr. Justice, Mr. Chief Justice, Justices. In light of how we kind of went through everything in that first section, I'd like to address a few issues that have come up and not necessarily follow along in an orderly fashion, but address some of the issues that have come up. On the TA issue, I think this is important. There's two issues with the TA and whether it was breached. And one is the term issue. In fact, Mr. Lorman, when I refer to Mr. Lorman, he's kind of the head man for TCB. He's the vice president. He's the record will reflect. He's a Yale-educated lawyer, clerk for a federal judge, been in the auto business as an attorney for many, many years. This facility serves primarily the auto business because Mazda and a few other entities park their cars out on the facility. And since the BNSF and UP come in there, they can pull them out and take them on down the road. But under the TA, he's the one that authored the documents. And he admitted that by its own terms, the TA doesn't begin until, and I need to give you the actual language, it's in there. The TA, the term of the TA, the term of this agreement, this is in Roman numeral 2 on the first page of the agreement. The term of this agreement will commence on the first day of the calendar month, immediately following the date that the engineer certifies in writing the completion date of those improvements pursuant to 1.5 of the railroad allowance agreement. And then it continues in effect for 10 years. So what that says is that agreement doesn't begin until the railroad allowance agreement is completed and their engineer certifies it.
Okay,
as
council,
being
we've got to
complete.
read, do you agree that we've got 2 agreements, or do you think we have 2 documents in 1 agreement?
I think we have 2 separate agreements. They both have integration clauses in them, Your Honor. But if you look
We
at
also
the,
have entireties clauses,
Yeah.
both of them.
correct. But if you look at the railroad allowance agreement, particularly the last section of the railroad allowance agreement, it does provide that if there are any cases of conflict between the two, the railroad allowance agreement prevails over any other documents.
And does that go to your argument that the utilities are not your responsibility? Or does that go to, they were not my responsibility yet?
That goes to they're not my responsibility,
Period.
because, and their pleadings, they filed amended pleadings to argue that in fact, the term utilities and provisions related to that were ambiguous between the 2 documents. In this courtroom today, they're arguing that it's clear the transload agreement covers all these. But in fact, if you look in the railroad allowance agreement under costs of construction, it talks about utility connections, permitting. I keep going back and forth once I get going. It talks about under actual costs of construction.
But what about the temporary versus permanency nature of the utilities? A very smart bird said to me that there's a difference between the poles sitting out there that you have to have during the course of construction, which could be obviously treated as utilities. Somebody's got to pay the bill. And the contractor's using that versus when you finally get to the end and you get to at or near certification, you got permanent utilities more or less. That's different. So what are you talking about? All of them, some of them, or none of them?
I think we're talking about all of them because it talks about connection fees, getting utilities there. And then, Your Honor, by the terms of the railroad allowance agreement, the railroad allowance agreement itself is actually 3 documents. It's the agreement itself, it's Exhibit X, and then it's the very back of it is the preliminary estimate of costs for TCB infrastructure improvements. And if you look at that document, it clearly includes utilities as part of the preliminary estimate of cost, especially in relation to water utilities. It has a whole section where it lays out water utilities that are to be brought to the site. It includes them in the 1.2 million estimated cost that's calculated. And then it footnotes it and says, at this point in time, it doesn't include things for Encore and gas because those aren't available at this point in time. But
Is that an indication that that was going to be added to the TCB infrastructure improvements and to the 1.2 million cost?
well, the $1.2 million cost, Your Honor, is a negotiated cost. I mean, that's clearly in the final agreement that was signed by the parties. It says that this is $1.2 million is the maximum customer cost for the TCB infrastructure improvements. Now, what it does say about the estimate, it does say that the estimate may change once it says that the estimate may change once their engineer looks over everything. But we have an agreement that we're going to be responsible for 1.2. The preliminary cost could go up, but we've already bargained between the parties as to what our amount is going to be, because that's a term in the contract. It says the maximum customer payment is 1.2 million. They are assuming that they're going to have to pay amounts that are over 1.2 million.
Do you could, as the agreements were originally drafted and argued, is it your understanding that the 1.2 million included utility cost?
Yes, Your Honor.
That it was at your position that the 1.2 included utilities as part of the TCB infrastructure improvement?
Yes, Your Honor. And
Where is it in that paragraph?
it is not in that paragraph. I'll admit that, but it is in actual cost of construction, which is not in that paragraph. Actual cost of construction are found at actual cost of construction. Are found in 2.2. And 2.2 says actual cost of construction mean all engineering, survey, testing, plan and permit fees, etc., incurred after the date of this agreement with or incidental to the construction of TCB infrastructure improvements. And the testimony at trial is that's included within the maximum customer payment. The testimony at trial from Mr. Lorman is that actual cost of construction is equivalent to actual cost of construction of TCB infrastructure improvements. So in essence, it's a clarifying provision that says there are costs of construction related to these things that will be concluded within the $1.2 million.
Okay, let's talk about the comma.
Yes, Your Honor. Open-ended, let's talk about the comma. Well, what I'm afraid of is we're getting limited by the comma. The intent, and let me just go straight to the comma and then I'll circle back. First of all, let me talk about their explanation of last antecedent and series qualifier, etc. They talked about the case, the note case, where they said this supports it because the way it's that third subsection, and
The
therefore
attorney's fees and cost case.
no, the note one is yeah, it may be, but it's the one. It's a case. I would describe it as the case where it's set off by dashes. There's a particular phrase set off by dashes, and the parties are trying to carry it. One party is trying to carry it outside of the dashes. That's not what's happening here. We're not trying to say, and they're not trying to say that it should come outside of the dashes. They're saying because it's contained within a specific subsection that it can't be the last antecedent, because the last antecedent must apply to that whole subsection. And that's simply not supported by the case law. We've cited the Supreme Court in Sullivan versus Abraham. It's a really good case for the whole description of everything that we're doing here today. But in that case, it's talking about a specific subsection, and it just applies the modifier to the last antecedent. In fact, there's an opinion called In Re Womack out of this court. Justice Davis wrote it. Judge Gray, you were on the panel as well and agreed with it. It's an issue where it's dealing with statutory construction, and the last antecedent is applied. Last antecedent canon is applied, and it's applied within only a subsection of the statute. It's like the third or fourth subsection, and you apply the modifier to the very last part of that subsection, and it does not apply across that subsection. So I simply disagree that because this is in the third section, that it means that that must apply across it. There's even another case they cite, Artiga versus State. Series canon qualifier is applied in that case. Justice Yeary says, I'll agree with it because I agree with the finding of the court, but I would point out that what they could do is use clarifying commas, as Sullivan versus Abraham talks about. And if the state really wanted to argue what they're arguing here, if they would have simply put a comma in one particular place, it would have solved this problem and we wouldn't have to be arguing about it and doing some guesswork. Because to be honest with you, the last antecedent canon it is a very constrained conservative canon. It has the least guesswork involved because when you get to the series qualifier canon, that's essentially us saying, well, we might get an absurd result if we do this, and this is what we qualify as absurd result. But with the last antecedent canon, it's pretty conservative because it looks at it and says it only applies to these words unless you give us some indication otherwise. It puts some responsibility on the drafter, in this case, Mr. Lorman, who is an educated lawyer and has practiced for some 60 years. Your Honor, it's not just one comma. There's two commas here that are important, and that is, there's two things they could have done here if they wanted it to say what they believe it says. They could have taken the comma out here. This is the one that Sullivan versus Abraham and Garner and Scalia would refer to as the Oxford comma. That is, it precedes that last item in the sentence, or the clause. If they would have taken that out, then they wouldn't have set off the rest of that by itself. But by putting that comma there, they did set off the rest of that, that sentence, if you would, by itself, showing that the modifier should only apply at the end. Now, if they wanted to, and this is, I think, the argument we were having earlier, but if they really wanted to make it clear, they could have put the comma right there between designated areas and as are agreed upon by TCB and the customer in writing. And that would have made it clear. That's the Supreme Court in Sullivan versus Abraham saying, if you do that, and Scalia and Garner saying, if you do that, you make it clear that it carries across. And they didn't do that.
I know you've testified, no, you've argued that the chief draftsman was somebody that worked for them. I got that.
Yes.
But also, did your clients have a full opportunity to do such as you're talking about grammatically, if they had chosen to do so when the negotiations were going on, drafting the documents at the outset?
There were some back and forth, Your Honor, but the fact that there's not a comma there would lead you to believe that my client's intent was not to have it modify the entire section.
But there was negotiations, and so the fact that you're arguing as you are, both sides had a chance to look at it, as far as you know.
It was not presented as a fait accompli. In other words, it wasn't presented to them and said, sign this, and there's nothing else. Yes, I agree with you on that.
Okay.
There was some talk back and forth.
On here, you're arguing about the agreed, the word agreed, and the incorporation of Exhibit X.
Corporation of Exhibit X, agreed. Okay. If I could move around a little
Please
bit.
do.
Let me point out one thing, because I think there's some confusion. This is something that was negotiated over time. It wasn't done on the back of a napkin. And so Exhibit X, I'm going to put it right here below this, and I realize it may not.
Go ahead and put it up.
Oh,
We can see if you're gonna make reference.
Well, it's a two-parter.
Sorry, we can only afford one easel.
Well, if I could, let me do one thing because this is the main part, but I wanted to point out to the court, and I won't put this up, but this document, Exhibit X, is drafted by Lunsford Associates, LC. Lunsford Associates, Mr. Rick Lunsford, is TCB's engineer. So TCB created this document. It was not our engineer, it was their engineer based upon the information he was given.
When you characterize him as their engineer, you're saying for this project?
Yes, in fact, Lunsford and Associates LC, you'll see from the record, is listed in the railroad allowance agreement as the engineer of record for this project.
Okay, and that is in front of us in the record for this case?
Yes,
Okay.
and he is the one that drafted this and completed it. I mean, it's in final form. So, Your Honor, you asked me what my position is on the agreed. It's clear from the language. Well, if you step back a little bit, there's a preamble above it that says what the intent is. We need transloading equipment. We need a facility where we can do this. And it says the intent is that they're going to provide infrastructure and we're going to provide our special equipment that we need. And if you read through the entire railroad allowance agreement, there's probably 5 or 6 places where it talks about their infrastructure versus our specialized equipment. And even at the last paragraph says, the last paragraph of the railroad allowance agreement makes clear that we don't have a property right in anything out there other than what we can take out of there, other than what's detachable. And that's the same, in the transload, it says the same thing. It says that they have the lease, we don't dispute that, and it says they have the real property interest. We have no real property interest. So as far as slabs and things like that, we couldn't own them. And we've talked about some other cases involving them where they've said that they actually own the slabs when they were trying to avoid preemption from, trying to preempt some regulation by Midlothian. But this makes clear in this document that we have no real property interest. We only have what we can move out. It talks about how we can go in and inspect the property to look at what they're doing so that we can coordinate with putting our specialized equipment on there and things like that. But it's clear if you read throughout, TCB infrastructure improvements is written so that it can apply to that $1.2 million. It's kind of a term of art for that. But there's no distinction between other infrastructure and TCB infrastructure. The distinction is there's infrastructure, which they're in charge of, and there's specialized equipment, which we get out of there at some point. And even if there's some obligation at some point that we might have to break up some of this stuff that's attached to the real property, that's not important because the argument is they own it. And if they want us to have to break it up, then we may have to go out and break it up. If they want to keep it, they can keep it. But going to this, it says that we've agreed to three things, and I've phrased it in the brief. It says the parties have agreed to the following. Let me be precise. As used in this agreement, TCB infrastructure improvements will mean the following improvements agreed to and shown generally in Exhibit X, attached and incorporated into this agreement by reference. So it says right there, TCB infrastructure improvements mean the following improvements agreed to and shown in Exhibit X. And then it lists a 1, a 2, and a 3. And I don't want to be glib or anything like that, but it doesn't say 1, 2, and maybe 3. It says we've agreed to the following things, 1, 2, and 3. And we're showing you that in Exhibit X. And as to number 3.
But as to number 3, isn't it generic in nature, basically?
Your Honor, let me look at number 2. 2 says, look at number 1. Approximately 3,000 feet of rail track, including 2 railroad transload tracks shown in the transfer area on this document. I would express to you that I think that's the same thing. They want to talk about how it's a non-exclusive list, etc.
Yeah.
But then they say in number 1, we know we've agreed to that. Well, my feeling on that is it reads just like 3, where it says including without limitation, those two things meaning the same thing. And then it lays out slabs for truck scales, racks, tank, and appurtenant structures to house personnel, heating and steam equipment, and planners for parking areas. And all of that's depicted in Exhibit X.
Show me the slab for the truck scales.
Truck scales are right over here, Your Honor. Back over in there.
Are they labeled truck scales?
No, it's labeled truck transfer area. But
Well, I see the area.
clearly there's curbs there, Your Honor.
I don't
Clearly
see
the
any
tanks.
planters.
Well, I don't see any planters either, but it may be that my eyes aren't good enough, but clearly and there may be some argument about, certain items here, but it clearly shows the tanks and things like that, which represents.
Clearly their engineer didn't determine the size and number of tanks, so he had to have gotten this from your guys.
The testimony is that he was given that information.
Okay, and so specifically in the language versus Exhibit X, there's also a pertinent structures to house personnel.
That's right here.
Okay. But the language is tank singular and appurtenant structures to house personnel. And I'm just going to general, trying to understand what this provision means. Are they putting the personnel in the tank? Because that's what the agreement says. And I'm sure that's not what it intended.
No, that is
But
true.
is it the slab for the structure, or is it the structure that is supposed to be included? And that's where I get very confused.
Well, I would say what's generally depicted there is where the structure will be along with where the slab will be. mean, you can't have a tank or a building or any of those things without a slab.
So is it your contention that it was TCB's obligation to pay for the construction of the tank?
No, that's important, Your Honor, because that 1.8 million did not include construction of tank, buildings, anything like that. The record will reflect that. I think that was a misstatement earlier. That's all, there's no specialized equipment included within 1.8. Marvin Small's testimony, I believe, is the place where you would go with that, and there's exhibits that are addressed in there. Everything in the 1.8 is what I would call infrastructure. We can argue about TCB infrastructure for the purposes of this proceeding and things like that, but that is something that needs clarification. We're not trying to include any sort of building, tank, piping, anything like that in those numbers. That is primarily concrete that is put in the ground as slab, or the undisputed mills work that was road work and things like that.
All right, it's one thing for it to be an obligation. It's another thing to have actually gotten it paid. Are you saying that your people paid 1.8 million?
Yes, and the record reflects that.
And the record does reflect
The
it?
record reflects that. And under the contract, we were obligated to pay 1.2,
Right.
and we would be paid back over many, many years at about $200 a time through railroad shipments. If I could touch on one thing real quick, and that is this issue about the contracts with third parties and whether the engineer was involved or whether it was approved. The issue, Judge, was not, I'm not even sure exactly how they would have gone about it, but they didn't make any arguments to the judge at any time that involving the engineer was unambiguous or was a term of art or anything like that. There's no ruling, there's no submission, there's no question that was omitted or anything like that that concerned the term involving an engineer. There's also no similar submission or objection or anything like that about approval and what approval meant as far as TCB's approval of contracts with third parties.
Were you in this all the way?
Yes.
What you're stating?
Yes, I was in this all the way.
Okay.
My point,
Except in the negotiation and writing it up.
correct. My point is that you have in the record all the objections they made to the charge. They chose to submit to the jury whether or not these contracts involved the engineer or were approved by TCB without any further guidance of an instruction or anything like that. In my mind, they can't complain about it now when the jury looks at the evidence and decides that there was not a breach of the agreement by my client or that they breached the agreement, and then try to pin it on, well, there's no way he was involved here, because I do think the evidence shows that I would cite you to, off the top of my head, Defendant's Exhibit 145 is one of them. It is a back and forth between their engineer, Mr. Lunsford, and another engineering company that's looking at the soils and providing information as to the tank foundations and things like that, and how they need to be poured, what needs to be used, etc. Mr. Shiver's testimony, he was our engineer on the ground, is that Mr. Lunsford told him, hey, this concrete and stuff like that was within my scope. We're taking it out of my scope and putting it in yours because you know better about what you need. Clearly approval of this process coming from TCB, but also involving their engineer and our engineer. And it's Mr. Shiver's testimony that, I believe it's Fugro, as you'll see in Defendant's Exhibit 145, does all the work. Then we have to have it for our concrete people to pour pursuant to that. Mr. Shiver's testimony, and it was not contradicted, is that TCB paid for all this work that was done as far as the work that needed to be done to prepare the pads, the work that needed to be done to tell us how to
That's
pour it.
Mills and the engineer, their engineer, right?
Yes, and a company called Fugro. You'll see that in Exhibit 145. So there was clear involvement with their engineer in all of the pouring of the slabs for our buildings and tanks, et cetera. And not only that, they paid for it, which is an indication that it falls under 2.2 actual cost of construction, talking about engineering, permitting, and things like that. If it falls under 2.2, by definition in 2.2, that is incidental to building TCB infrastructure improvements because they had no obligations to pay anything other than items towards TCB infrastructure improvements. So not only does it show involvement, it shows that the slabs are TCB infrastructure improvements, and it also shows that they approved it by taking it out of the scope of work that was theirs and telling our people to do it.
I need you to talk about the TA and the issues on the TA agreement,
Okay.
the jury charge issues. Where are you on that? And
On the jury charge issues, Your Honor, I think you'll see it's in the record. We didn't object to the way the jury was charged. The jury was given a broad form submission on whether the railroad allowance agreement was breached or materially breached, and the TA, whether it was materially breached or breached by either party. And they were told to go look at the evidence and make your decision. They didn't preserve anything.
all right. Now we're back at 30 minutes for both of you, and I'm going to have to apologize to Steve later. Okay, I need you to do something that is going to be foreign to you, that is going to be difficult. And I'll get to the flip side of this question when I get to the rebuttal, but assume with me for a moment that we disagree with you on the summary judgment by Judge Carroll. What is the remedy for the total case? RAA, TA, where does it go? What happens? What can be still affirmed with if we disagree? And I think it's issue one. Where are you?
Your Honor, the way they approached it, well, it would have to be did it cause an improper verdict, essentially. I don't believe it did because their argument was that this secondary thing about approval and things like that and involvement, that kind of solved the issue because they would have been arguing that either way, that we didn't have that issue and the jury resolved that against them. But I guess ultimately to get to the heart of your question, Your Honor, the TA questions would not have to be relitigated because they've been decided. The jury's heard all the evidence. I don't think our damages need to be relitigated. Now, it might be odd if you're relitigating the liability portion, but our damages, they weren't objected to. As far as how the charge was given, the jury was given the evidence on what our damages are, and the jury made that decision based on the evidence. And I would say the same thing about the TA.
So you don't think you would need or want the opportunity to go back and prove the 13.9 or 13.4 million damages?
I'm happy to take the damages that were awarded.
Okay.
And then I suppose what would be left would be trying the issue of the railroad allowance agreement. I don't think it's necessary, but if that was the court's ruling, that would be what would have to be done. And I guess at this point in time, I'm not sure what their position is, that the jury decides that because it's ambiguous, or we go back again and try to convince the judge that he should decide the other way.
I can tell that Rex still has a question lingering about something.
No, because we're pressed for time and you're doing a good job of condensing for me. I'm good. Thank you.
Okay. Question? All right. Thank you, Councilman. And contrary to what the clock says, you do not get another 30 minutes.
I'll take it. So briefly,
Okay, I've got to ask you the same question because I asked him and promised him that I would ask you.
So-
Assuming we disagree with you on the ambiguity question, excuse me, assuming we agree with you on the ambiguity question on the first issue, where do we go?
So it depends if you determine it's ambiguous or you rule for us. If you rule for us, then you render for us, and they don't. We didn't breach the RAA. You remand the case.
But assume ambiguity.
Okay, if it's ambiguous, then the court would send it back to the trial court for a new jury trial and a question on what was the party's intent with regard to 1.1 under the RAA. It also reverses under the TA because, first of all, I don't think the court can sever those two claims out. There's no way that the jury here listened to and found that we breached the RAA and awarded almost $9 million against us, and then somehow just totally put that out of their heads in determining what the breach was under the TA. And specifically, these issues are interrelated between the two agreements in this way. So utilities are not TCB infrastructure improvements. They're not. They do impact the 1.2 million because, your question?
I'm trying to remember, to get my hands around the concept that Rex was talking about, or my mind around that concept of utilities, service utilities during the construction phase versus the utilities serving the plant once it is operational. And I'm trying to figure out if you're making that distinction or if this is all utilities.
So they actually kind of come into play in the agreements. Under the TA, we're talking about taking the utilities from where they were before over this raw land and hooking them up. And they had to reimburse us for that. Under the cost, and so as Judge Gray noted, there is no reference to utilities under the definition of TCB utilities. Under 2.2 of the RAA, which is what Mr. Peck was talking about, it says actual cost to construction means a number of things, including utility cost. Utility costs there are talking about the electricity and water that we're using to construct this stuff, not the construction of utilities out to get there. And so that's why the RAA does not deal with bringing utilities out there. That's what the TA deals with. And under the TA, if they had elected in writing, they could increase the 1.2 to 2.2 or 3.2.
Whatever they paid for utilities.
Whatever they paid for utilities. But they never made that election. They never did that. So they have to pay us for it.
And they would get their utility cost back $200 a tank.
Right.
Okay.
First of all, I do want to clarify, both the TA and RAA was a heavily negotiated document between both parties, and they had a lawyer representing them in negotiating it. So I want to make sure that's clear on the record. I touched on the utility.
They had a lawyer other than the Yale guy?
That's our guy.
Okay.
Warman is our guy. They had their own outside counsel, or maybe in-house counsel, I don't know, but their own counsel looking at it as well. Exhibit X that was talked about a lot. I want you to look at this. It's important because all of this stuff right here, all this stuff that's theirs, is not built that way out there. If you go walk out there, it doesn't look like that. This was just
that in the record.
Please.
The as-built diagrams.
I don't know.
Yes, Your Honor, there will be exhibits that show as-built, and there's probably some photographs as well that will show what it looks like.
Okay.
So this was merely a preliminary, it says preliminary look at. And so this is what our guy guessed. This is a guess. And so that's why we have to have a meeting of the minds and agree on what this stuff was that we're going to have to pay for it if it falls under the 1.2. And also, if you want to go, they mentioned utilities attached to the document. There wasn't Exhibit X, but attached to the document was this preliminary kind of estimate. There were some utilities mentioned. There were also other utilities not mentioned. You know what else is not mentioned? The cost of slabs. So under their argument, they lose because the three contractors they paid, they're trying to stick us for the slabs under the tanks, that wasn't listed on that. So that argument hurts them more than it helps us.
You understand you're rolling toward document, not just document ambiguity, you're rolling toward basic subject matter ambiguity, which means reverse and remand might be in somebody's future. We just don't know at this point.
You know, as I was getting ready for oral argument, I pondered to myself, was this even an enforceable document? I mean, was there really a meeting in the minds on this that a jury could say that someone breached it? But maybe that's what a trial court could look at upon remand. But clearly, Your Honors, we'd ask the court reverse and render for us on this contract construction issue, or at least find it's ambiguous and send it back to a trial. We need to get this resolved without the trial court's instruction. That was erroneous in this case. Thank you for your time today.
Before you close it. Right there, because we've got a little technical problem. Please address for you too, that I'm not Matt Johnson, that he was, that's all right. He was recused. I don't think have to go into all that, but anybody that wants to look at it needs to know we did it right way.
In the first arguments today, I had actually my name in place of the council screen, and I apologize for that technical issue. And then Rex Davis has just pointed out to me that I failed when I restarted YouTube to change the name of the justice for that screen from Justice Matt Johnson, who is recused in this case, and instead it is Justice Rex Davis, who is the justice that actually heard and sat on the panel.
And I appreciate the recusal because Matt Johnson's never agreed with me my entire life. He will start now. Thank you.
And I'm going to, for the sake of the YouTube channel, I'm going to fix that. And it will be there briefly for anybody who sees it.
Thank you.
And that's the way it'll show at the end of the YouTube channel presentation. And I apologize for that IT oversight. I've been janitor today. I've been the IT guy. I've been the access guy and the plumber. So yeah, we've done it all today and still got through the oral arguments. And with that, I'm going to close the live YouTube channel unless there's anything anybody else wants to say on it too.
Thank you.
Okay.